Thank you. My name's Alan Limbury. I've been a lawyer for 52 years, and I was a litigator in law firms here in Sydney for 32 of those years. I've been mediating since 1987, and for the last 20 years mediating and arbitrating on my own, with my own business. I still have a practicing certificate as a sole practitioner, so I might use the word we occasionally to mean us lawyers today, but primarily I'm coming from the dispute resolution point of view today, and I've given you some written material which hasn't yet been published, but it tracks a bit of the development of ODR over the last few years, and in particular mentions some of the moves afoot in other countries, particularly the UK, towards fully online court systems, which we're going to have to deal with. And I'm not going to go through all of that, but it seemed to me, in thinking about it, we need to think about what lawyers need to do to stay relevant. And lawyers want to help their clients achieve a good outcome. We want to be consulted early and be seen as relevant to our clients' business and life decisions. Now, David Maister said that in The Trusted Advisor, and we all know it to be true. We complain quite rightly about not being consulted early, but we haven't accepted any responsibility for that. And online dispute resolution will only make that worse. It's going to cut us out completely in many situations. Now, notifications to law cover, which become claims against New South Wales lawyers, are reducing significantly. But what is not reducing is the proportion of claims attributed to poor client communication. And this has stayed stable for at least the last 25 years at close to 50%. We already know that ODR presents communication challenges, and this is likely to make things worse, not better for lawyers and their relationships with their clients. So in a world where no one is paying attention and everyone is distracted by devices, lawyers run the risk of defaulting to this behavior and not building their communication skills. If we don't do this, we will be replaced by an algorithm. And in the words of Dr. Rosemary Howell, lawyers today are the chauffeurs of what are about to become driverless cars. And while ODR seems to be an unstoppable force, the profession needs to think more strategically about it, not just for lawyers' self-interest, but in the interests of our clients. Some points are doing the right thing for the right reason. Now, ODR has gained a lot of traction because it fits the cheap and quick model, and we're paying a huge price for selling ADR in general and ODR in particular as cheap and quick. Instead, the focus needs to be on a good outcome for our clients. We need to be efficient, but we also need to be effective. And sometimes that is not cheap or quick, but it does produce enduring solutions which have better value. So what we offer that software cannot is wisdom and judgment. And lawyers need to admit that we have hijacked mediation. The drive to an evaluative process has killed the promise of mediation and also made it easier for ODR processes to be introduced without consideration of whether the circumstances are appropriate. So ODR clearly has a role, but it needs to be a situation-specific choice. Where valuable business relationships are at stake, for example, parties often need to talk face-to-face to investigate what their relationship means and how it might be restored. And if, as Malcolm Muggeridge said, and as I believe, no dispute is about what it's about, the risk of ODR is that it may be used to address only the symptoms. The problem will remain obscured and unresolved unless we lawyers concentrate on ascertaining and addressing our clients' real interests and using ODR as a means to that end.
Do you see ODR as having a much broader impact? And do you see ODR having a much broader impact on dispute resolution? At the moment, its focus is pretty much at the lower end of the dispute scale, the smaller dollar value disputes, if I might describe them that way. To put it bluntly, do you ever see it heading up towards the Supreme Court or the Federal Court?
I do, and I've pointed in my written material to the way in which those suggestions are being made in the UK. It was first implemented in one of the states of the US in 2002, but it didn't last. But I think things have moved on since then. And what's now being suggested is that even without the assistance of lawyers, disputants would be able to obtain legal information online, to go through a triage process, which may or may not even involve a human being, and to have their dispute considered and dealt with by a judge over however long it takes, without any kind of a physical hearing at all. Now, it's going to take a while for that to happen. And the interesting thing about ODR, I think, is that just as ADR is taking hold through generational change, particularly graduates from law school who are actually being taught negotiation and ADR these days, so ODR is also going to be a matter of generational change. So those two concepts are both going to take generational change. But when you think about it, it took equity, I think, 65 years between the appointment of the first Chancellor and the decision of the Attorney General in the UK that equity overrides the law. And we've only been going in the modern era for about 30 odd years at ADR, so we shouldn't be too impatient.
Questions? Are you saying that litigation lawyers are at risk of being sidelined in the process? Is there a role for them in ADR, or potentially
I think
they could lose out altogether?
There's a huge role for them in both ADR and ODR. I think the way Sir David Ryder put it in his lecture this year was to look at the court litigation as a problem to be resolved rather than as an issue to be determined. So just as when we go to the doctor, we're expected to say how we feel and what's wrong with us, when we go to a lawyer, we're expected to say who did what to whom, and the lawyer is listening for whether you have a good cause of action or a good defense. We need to think more about what's it really all about. What are the real concerns of the client? What are their real interests? Do they actually need to litigate this, or is there some other way of dealing with it? So if we can turn our litigators into dispute resolvers, there'll be a very important place and very important role to play.
And do the universities have any part to play in this? Any part to play in it? Do the universities have any part?
I think universities have a huge part to play in it. It's good to see, and I'm participating with my wife in teaching ADR and commercial mediation at New South Wales and Melbourne University, and negotiation, none of which were taught when I went through law school. So the kids coming out of law school are actually going to be asking the why question. Let me give you one example, and I think you might have heard it already, Gary. There was a patent dispute where infringement and validity were an issue. And each side had spent $500,000 getting to where they were when they had the mediation, with about an expected $300,000 each to spend before even a first instance decision. And there were patent attorneys and lawyers everywhere. The inventor revealed that when he started all of this, he thought the defendant was going to come into his sector of the market. The defendant wasn't interested in that sector of the market. It wanted to be in a totally different sector. So they emerged with a license agreement between them which had geographic restrictions, which are permissible under our competition law. The patent remained on foot to protect them both against the rest of the world. They could have done that $1 million earlier if they'd been asked the why question. And that's where I see the role of lawyers today. Now, that doesn't necessarily mean that all cases are going to be resolved by some creative solution. I used to do a lot of defamation work for Consolidated Press when Frank Packer was involved. You can see how long ago that was. He would litigate every defamation case brought against Consolidated Press. And even when he was told, but this person is completely innocent, you've defamed the wrong person, his instructions would be fine. It took me years to work out his interest was sending a message to the rest of the world, don't even think about it.
Any questions? Yep.
One of the advantages, it seems to me, of ODR in particular is it's the ability to use it across geographical problems, so regions, states and internationally. I just wonder if you've got any comments on the technology that's needed to do that and how that's progressed over recent years?
Yes, well, my early experiences of email were that almost every communication would be misunderstood. And I had one once between a UK bank and an Australian. I met the Australian briefly. We had thereafter email communication, which was no problem. Every communication I sent to the man in the UK and he sent back to me were misunderstood by the recipient until it so happened I was over there and we had lunch one day. From then on, we understood each other. So it's prone to misunderstanding. The asynchronicity of that type of communication often breeds suspicion. The mere fact that somebody hasn't responded instantly leads you to sit there worrying about what they might be trying to get away with. So email doesn't really work very well unless it's between people who already know each other. However, video conferencing these days, I find, almost as good as face-to-face. I had one down at the Australian Disputes Centre a couple of years ago with some people in South Africa. We had to begin late in the day because of the time difference. But I could see them very sharply at their end, and they could see me with the Australian party, and I would take him into another room if we wanted a private session and come back, and they could see me on my own. At the end of it, when they reached an agreement, I started wondering, well, how's this going to be recorded? And the people in Johannesburg texted their counterpart, who just replied, I agree. I guess that's how they did it. And I think also Telstra and Optus have extremely high quality video, which is even better than what we get from them. So they can mediate their own disputes quite well. And one gets, as I say, almost as good a rapport as one does face-to-face. So the mere fact that it's not face-to-face isn't necessarily a complete barrier. There are concerns, though. You still have to be worried about security. Is there somebody in the room on the other side that you can't see who's whispering into or receiving information that they shouldn't be? All those types of things need to be dealt with, but we lawyers, I think, need to see this as a tool to be used in a constructive manner. And if we aren't constructive about it, we're going to be left behind.
Another question?
I was just going to, my observation is that the largest ODR providers are privately owned and the technology is privately developed. To what extent do you regard it as important that this technology that there be public investment in some of these technology solutions, say, for instance, the Australian jurisdiction.
Sorry, what is it?
Really, who's owning the technology is what I'm asking. The largest ODR providers, the technology is owned privately, that's at least my understanding. To what extent is it important that some of this technology be developed and owned by public institutions in Australia?
I don't regard ownership as a problem, because the way in which, as I understand it, the way in which the technology owners go about it is simply to make it available. They might get a few cents per time it's used. When you look at ICANN, for example, sitting at the peak of the domain name system, for every domain name that's registered, they might get a fraction of a cent. Last I heard, they had $300,000 US, even after having 12 trips around the world for hundreds of people every year. So they're awash with money. I think likewise the developers of some of these ODR systems, which have what you might call mediation rooms and facilities to interact both by video, telephone, or the equivalent of email, their aim, I think, is to enable practitioners to use their systems rather than to keep them private. They're going to make more money by allowing them to be used and getting a tiny fraction of something than keeping them private.
Yeah, I guess the control over how the process runs then is determined by the private company as opposed.
I don't think that's right. I think, well, it's certainly not the ones that I've seen recently. Modron, for example, which is quite a recent innovation, has a whole range of tools which are at the disposal of the mediator and at the disposal of the parties. So you can actually choose which particular tool to communicate you want to. You can choose whether you're communicating with one side or the other or both. So I find it's up to the users to decide how to use it rather than to follow some strict process which might inhibit the outcome in any particular case. So it's actually just as flexible as a face-to-face event.